For a lot of reasons, today is an extra Wheaties and extra cup of coffee day. This show's a little bit of work, I have to admit, but it's important work. Before the break, I told you at length about the independent state legislature theory, which is at the center of the Moore v. Harper Supreme Court case. At stake is the question of who runs U.S. elections and who sets election law. The plaintiffs in the Moore v. Harper case are using the independent state legislature theory to push a heavily gerrymandered congressional map in North Carolina, which gives an extreme advantage to Republicans. This is from the North Carolina Superior Court that first heard the case. Quote, the court finds that in every single one of the 52 elections decided within a 6-point margin, the enacted plans give Republicans an outright majority in the state's congressional delegation, the state House and the state Senate. This is true even when Democrats win statewide by clear margins, end quote. Now, in February, after some back and forth, the North Carolina Supreme Court struck down that map and ruled it unconstitutional, which is kind of the way it should work. But the plaintiffs took it higher to the United States Supreme Court, and that clearly unfair map that the North Carolina Supreme Court called egregious and extreme is now at the center of Moore v. Harper. If the Supreme Court rules in favor of the plaintiffs in Moore v. Harper, it will affect more than just one congressional map in North Carolina. It could give state legislatures full, absolute power over elections without court oversight. All right, joining me now is Dahlia Lithwick, senior editor for Slate, host of the podcast Amicus, and she's also the author of a new and very important book called Lady Justice, Women, Law, and the Battle to Save America. Dahlia knows more about Supreme Court-y kind of stuff than anybody I know, but I wonder if our camera could just move your mug for a second, Dahlia. Just push it forward. The mug. I want them to see. You have even come with notes, because that's how important and complicated this issue is.
It is a 6-posted day.
It's a 6-posted day. So I want to tell our viewers about the two theories, the two clauses upon which independent state legislature theory is based. Number one is the elections clause in the Constitution. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. So that's number one. Number two is the presidential electors clause. Each state shall appoint in such manner as the legislature thereof may direct a number of electors. So the plaintiffs here are saying, this is up to us as state legislatures to make the rules. The courts can't tell us that what we did is wrong, unfair, or egregious.
Right. That's posted 4. And essentially, there's 2 different provisions, and they really attach to 2 different things. One is the question of just simple state congressional elections, and that's the Article 1. The other is the electors. And as you said before the break, that's the clause that John Eastman and folks like Donald Trump were pushing after they lost, when they pick up the phone and call Brad Raffensperger in Georgia and say, oh, just make up your own set of fake electors. Just call that election null and void.
And Brad Raffensperger, by the way, in his reading of the law at the time, said, I can't do this. For instance, I've talked about Brad. I don't know whether he would have liked to have gotten the 11,000 votes for Donald Trump, because I believe he voted for him, but he believed that the law said he couldn't.
Right, because at that moment, everybody except John Eastman, Donald Trump's lawyer, believed that the law said he couldn't. Nobody subscribed to this. What's really chilling, and I think you got at this in your introduction, is that in the span of 2 years, we've gone from an idea that is deemed crackpot and insane and fully not rooted in text and history in the Constitution to an idea that comes to the court with amicus briefs, with very well-funded donors who are saying, oh, this would be a cool thing to take all power away from state legislatures, from state Supreme Courts, from the governor of a state, right? Because a lot of these are states that might have a Democrat in somewhere as the governor. All of those people lose power. The state Supreme Court cannot analyze these cases under state constitutional law because the only one who is the arbiter of this is the U.S. Supreme Court. So that's just chilling, and it happens so quickly, and it was such a power grab. And as you say, it's so arcane that it's entirely possible to blink and miss it.
So, but in the event that this happens, if the Supreme Court says, yeah, you're good, you guys are right about this, the legislatures have supremacy. This is not a North Carolina specific thing. This could happen everywhere. And if you overlay that to the 2020 election, Donald Trump might be the president today.
Oh, without a doubt. And what they were trying to do in Georgia, they were also trying to do in Pennsylvania, in Arizona, right, with audits.
Right.
What they were trying to do in Wisconsin, this was not a one-off in Georgia. We have the tape from Georgia.
Right.
But I think it's fair to say if you have 30 out of the 50 states that have Republican-dominated legislatures, it's very clear both what would have happened in 2020
and what
could happen in 2024.
So let me ask you this. A reasonable person would say, I vote for my state legislature. Why shouldn't they have supremacy over elections? And doesn't the Constitution say here that each state shall appoint in such manner as the legislature thereof may direct a number of electors?
I mean, the formalist constitutional answer is that the state legislature is not a free-floating entity that derives its power from itself. A state legislature is a creation of a state constitution, right? It's not a thing. And so the idea that it then trumps the state constitution or the state Supreme Court, which is tasked with enacting the state and enforcing the state constitution, is ahistoric and wrong. But I think the deeper thing is that, as you noted when you read it, Congress is supposed to be a check.
Right.
There are state courts are supposed to be a check. In a 2019 case called Rucho, this is posted at 5, the U.S. Supreme Court said, we're going to get the federal courts out of the partisan gerrymandering business, but you can always go to your state Supreme Court.
So the analog that my viewer might use here is that the Congress of the United States can pass laws, but they can be challenged at the Supreme Court, and the Supreme Court can say that law does not comport with the Constitution of the United States. It's an illegal law, so you have to fix it or you have to do something else. That's the point here, that you cannot take the power away from the state constitution or the courts to be able to say you've done something wrong.
Right. I mean, if you think about the very nature of the founding documents, it rests in the idea of checks and balances. Nobody has uncheckable plenary power to do whatever they want. And the idea that you're going to give a state legislature, an entity, by the way, that the founders were very dubious about giving them plenary power over anything, that they're going to have unreviewable, uncheckable power, and that the Supreme Court is going to determine without any state intercession whether that's fine, that's just so utterly doctrinally wrong and sort of constitutionally wrong and also historically wrong that, as you say, this is an idea that was hatched. It's cited to as though this is a true thing. It's a Rehnquist opinion that got 2 votes in Bush v. Gore. It's entirely fictional, and calling it the independent state legislature gives it way too much credit. Yeah,
that's the problem. It's a benign name for something that could be very dangerous and very damaging to democracy. Thank you for bringing the notes and for making this clear to us. We may have to have this conversation many times so that folks understand this. Just keep in mind that this is a very, very important topic. Dahlia Lithwick is the senior editor at Slate and the host of the Amicus podcast, the author of the truly captivating new book, Lady Justice: Women, the Law, and the Battle to Save America.